All right. Good evening, everyone, and welcome to the third webinar organized by Mediation Initiative. Now, we have been organizing these webinars with the hope that more and more people get introduced to the concept of mediation and understand what it is and how mediation applies in different domains. And that is why we have chosen to uh, select topics that would be very specific rather than just selecting general mediation topics, which we will be doing. But then we decided that it would be wonderful to start off with very specific topics that could help give you a better insight into some very specific niche fields. All right. Now, what Mediation Initiative is we are a mediation services provider. We provide mediation trainings and also provide mediation consultancy. So with this idea in mind, to increase mediation knowledge and mediation awareness, we are hoping to start today's mediation as well. And for today's webinar as well. And for today's webinar, we have with us Mr. Akshay Nagpal. Quick brief about Akshay. Well, Akshay and I got introduced to each other during our mediation course last year, and he was a wonderful batchmate during that. He actually was very difficult with me in a mediation simulation that we had done, which I have to thank him for, because without difficult role players, it is otherwise it gets boring. Otherwise, Akshay is very senior in the profession. He has about 17 years of practice. He has done his LL.M from the Columbia University School of Law in New York, and currently he is a partner at Saraf and Partners, which is a very big and national law firm. He works in majorly corporate law and mergers and acquisitions. He is also, like I said, he was with me in the mediation training course. He is a certified mediator, and he is also a certified coach accredited by the ICF Institute. And another interesting thing about Akshay is that he has been practicing heartfulness meditation, not mediation, but meditation, for more than 11 years, and is a heartfulness meditation trainer as well. So I hope we will gain a lot from Akshay's experience and what he has to tell us about mediation in shareholder disputes. So Akshay, I invite you to take the virtual stage and take us through this very interesting topic. Over to you.
Thank you. Thank you for a very generous introduction, Mihir. And the way I see this webinar going is that it's not a one-way traffic. It's actually, all of us will be contributing, and I'll try to. It's designed in a way that to make it very, very interactive, and yeah. So let's go ahead with this. Okay, so today's topic I think that we have is mediation for shareholder disputes. And I'll just do the slideshow. Yeah. So the agenda of today's webinar is divided into two parts, right? First, we will kind of just discuss and understand a little bit about shareholder issues and shareholder disputes. And then we will dive a little bit deeper into mediation, starting with what mediation is essentially, and why should we be actually adopting mediation for shareholder disputes in particular. What are its advantages? What could be some of the downsides, and how mediation would really work? What kind of issues may come up when we do, mediation in shareholder disputes? I'm assuming that it's a audience which is well aware with company structure, which has shareholders, and typically shareholder disputes don't come in a widely held company where everyone has very, very small shareholder stake. But in companies where there are 2, 3, 4, there are limited number of shareholders, right? And some of the very famous shareholder disputes that we may have seen in press is very famous Tata versus Cyrus Mistry, right? The Tata Sons dispute. All of us are aware of that. It was essentially a shareholder dispute, right? Of Tata Sons, with one of the majority shareholders, 18% holder, wanting certain things, whereas another shareholder, which was a trust, and the trustees of the trust wanted something else, right? And it all landed up through various courts in Supreme Court. The other very famous or infamous shareholder dispute has been Indigo, Interglobe Aviation shareholder dispute between Mr. Rahul Bhatia and Rakesh Gangwal, right? That has also been all over the press. And many a times we have seen various shareholder disputes in family setups also, right? Like famous Mukesh Ambani versus Anil Ambani back in the day, right? Munjal families, and so on and so forth. So this is not something which is uncommon. This is quite common. And yeah, let's see what all happens in this. So as a corporate lawyer, I have had a lot of experience in dealing with shareholder issues like formation of joint venture agreement, shareholder agreements, as well as dealing with disputes which are related to shareholders. So first, we are delving into the shareholder issues and disputes level, and here I would like to open the floor. Right, we'll begin with that rather than me telling anything here. What do we think that two or more shareholders would want to come together and start a new business? Or let's say there is a business going on, someone would want to invest in this company, become a shareholder, and then continue the business. Why do you think people would come together, form a company, and do business? And what I'll do is I'll use this tool of annotation, and type whatever responses come, and we will then see how it goes. So the floor is absolutely open, and would really welcome your thoughts. And no answer is incorrect, correct, right, wrong. So please feel free, from Himanshi to everyone. Feel free to provide your inputs, whatever you think, logically, commonsensically, or out of your experience. Why do you think shareholders would want to come together?
So, to generate profits?
Sure. Yeah.
Yes.
Pooling together of funds.
Okay.
Pooling together of funds.
Okay.
A pooling together of expertise.
Sure.
To be part of the growth story.
Any more responses?
Sharing of losses as well.
Sorry, could you repeat yourself?
Sharing of loss, apart from profits, sharing of loss as well.
Yeah, so of course, so sharing of loss. Well, why should one person bear all the loss, right? I'm loving this, whatever is happening on the screen. So any more inputs? Yes, Amir, I think you want to say something.
Yes, I was saying growth.
Growth.
To grow together.
Grow together. Let me actually, okay, this doesn't allow me to bold or do something. Let me try to do something of this sort. Okay, we missed some of the thing. Okay.
I think a great amount of money can be pooled in, and an individual is at a minimal risk of getting bearing the losses individually.
Sure. So I think we have covered that, right? Pooling of funds and sharing of losses and growing profits
Brand creation.
together.
Brand creation, and something new. And
So why would they have to come together for brand creation?
because the teamwork is required.
Hmm. So again, brand creation together, right? Yeah. Okay. Anything else? This is all relevant, very, very relevant, whatever we have on the screen. And there are no rights and wrongs.
Raise funds.
Okay, raise funds. One is pooling of funds and one is raising of funds. Again, raising of funds, I would say together or leveraging strengths, mutual strengths, right?
Reputation, to maintain the reputation of the.
So can we say to enhance reputation?
Yes.
To enhance reputation jointly, right?
Yes.
Because they both believe that we can together enhance more reputation, right?
Yes.
Okay. Yes. Okay.
So one more point, to provide services or goods to the society.
And why would they not be able to do it individually?
Maybe, sir, because, one person has a brand name. He's, more famous. So maybe, and one person, has a public, appearance, and the other, is good at, dealing with all this business. So, maybe they come together, it's a win-win situation.
Right. Yeah. Mm-hmm. Okay, so I think our board is almost full, right? There is no more space to write. And thank you so much for your inputs. In fact, it indeed has enriched this discussion because next slide just had few of my thoughts. And you would see that there are one lot of overlaps already and also some very, very valuable additions to that list, right? And one thing which I noticed in most of your responses was sharing, together, pooling. So essence is that where two or more people think it is by coming together that they can make 1 + 1 = 11, right? Separately, they can't do something, right? They can't make profits, they can't have funds, they can't build on expertise, they can't grow, they can't create a brand, they can't give services to society, they can't enhance reputation if they are doing on their own. They see some mutual symbiotic relationship between the two parties, right? I think I need to stop animation. Oh, I have to actually, I think, first erase this stuff. Okay, so yeah, these were some of the things that I had thought, right? First and foremost, to do business together, right? To make profits, we had in there. To turn their vision into reality, I would say this is common to like enhance reputation or create a brand, right? To leverage on strengths of each other, create synergies, right? There are many examples like a foreign player gets technology, an Indian player has capability of managing the project, like acquiring land, government relations, and so on and so forth, developing markets, and both of them uh, take their synergies and create their synergies to do something together, right? To meet their own business interests through JV. Like someone wants to supply raw, they make very good components, right? Or they have raw material. So they want to make a JV for producing something in which they will supply their own raw material, right? And the other company has manufacturing facility. So they will use their manufacturing facility, but they will need that critical raw material. So those are the reasons. And two major buckets which kind of define the shareholder relationship is either a shareholder is a financial investor where he is invested or become a shareholder like private equity funds, venture capital funds, or they are strategic investors, right? Like what was being seen as Ford Mahindra JV, which never happened, or there are different kind of joint venture companies that we are aware of, right? Which are like in the insurance sector, there are many. Okay, so we won't be doing annotation now, but actually we can do that too. But some oral responses. So what do you think is needed to keep a shareholder relationship going? What do we need between two shareholders to keep it going smoothly?
Mutual respect.
Mutual respect. Wow.
Transparency.
Let me actually use and okay, mutual respect.
Transparency.
I think I'm going to be redundant very soon here, and I am so loving it. Yeah.
Focus on goals.
Transparency.
Focus on goals. Long term.
Focus on goals. Okay. Yeah.
Clear communication.
Clear communication. Yes. Anything else? Yeah, so this is pretty awesome, right? And because we have text, I'm just taking it away. So yeah, I think we didn't need this slide, right? And our responses were so bang on. So it is mutual trust and respect, because what I have seen in my experience is that, many a times agreements may say whatever they say. Like they may give power to one of the parties to veto, to overrule, uh, and so on and so forth. But the day those rights have to be enforced or triggered, you can see that the shareholder rapport and shareholder dispute has arisen, even though everything is happening as per the agreement, right? Because essentially, irrespective of the shareholding of the parties, if unless it's a very minority shareholding or something like that, usually all decisions happen by consultation, and people bounce off, use each other sounding board, and collectively decide or take those decisions, right? And mutual trust and respect, if you would see, is underlying. But even if you have been following Cyrus Mistry versus Ratan Tata dispute, right? There may be issues on the certain director resolutions, etc. But ultimately, it was about both parties needing respect. Like Tata's needing respect of being Tata's, and they wanting some respect as being a majority shareholder too, right? And it was also a disalignment on direction of the group, direction of the company, right? We mentioned in our annotation focus on goals. So that's definitely one of the things which is needed. If both parties think, okay, we need to operate, like let's say one party thinks that we need to spend more, right? We want to burn capital, we want to capture growth. The other party says, no, till we are not profitable, we have to keep a per unit profit. We can't be investing and burning money for growth if our per unit profit is not there. We need to be slow in growing revenue, but our profit cannot, we can't bleed. Then what do you think will happen to the company, right? How will both of them take decisions? Because the quality of decisions in these two directions will be so different, right? Keeping their fiduciary duties, right? For example, if someone wants to get all related party transactions and want to give more benefit to the companies in which they are 100% owners at the cost of the company in which they are only 50% owners, then they are not acting in interest of the company. So it is not in the best fiduciary duty that they are adopting, right?
Akshay,
We want to say something.
Yes, may I just stop you there for a moment?
Yeah.
You used the terminology related party transactions.
Yeah.
And I think it would be very beneficial for the participants to understand the parameters of that term.
So a related party transaction means that, let's say there is a company. So me and Mihir, let's say both of them, we set up a company, right? And we are 50% shareholders in that company, right? And that company needs certain raw materials. And I own 100% a company which supplies raw materials, right? So me being in the driving seat of that JV, I would say, or let's say I am 51% and Mihir is 49%. So I have more control. And I end up signing contracts with my own company in which I am 100% owner, right? Not just 51% owner, at the price which is above market price. So I'm giving more money to a company which I own. So thereby at the cost of a joint venture company in which I lose only 51%, I give more benefit to the company in which I'm 100% owner, right? So that's a related party transaction going wrong. It is sometimes necessary to have related party transactions, but the trick is to do it on arm's length and fair basis, such that even if you had gone to market for the same raw material and the same quality, you would not have got it at a better price, right? So then there is no harm done to the JV company. But many a times when that standard gets missed, then problems arise. And you would see in every shareholder dispute, you would always find an allegation of a related party transaction. The meaningful communication and consultation, I think that also was on the board, right? How do we keep communicating and consulting? Because many a times we think that we can take a particular decision without informing the rationale about that to the other party. We are in control, right? But the other party just feels they are sidelined, right? So to keep a healthy relationship, these are the elements many a times which are important. And why we are discussing this is then we will see how these very elements become reasons of disputes and how we can use this knowledge and understanding to mediate the disputes between the two. Because when disputes arise, they look very different in their shape and form. But let's see the fundamentals of a shareholder relationship, right? Then keeping shareholder agreements. If there is a non-compete agreement, then we really follow it. If a shareholder gets to know that someone is trying to do the same business somewhere else, using their wife, using their brother-in-law or something like that, that's never a good taste. And both, if you see, we discussed initially that why two people come together. They come together because they have respective strength and they need to contribute together, right? So unless shareholders have confidence that both are indeed contributing as per their original expectations, I think things will not go smooth. Okay. So let us again see what could be. Now we have understood what is needed for a good relationship. So let's flip the question, right? What do you think are some of the common causes of shareholder disputes? It's like a flip question. So can we have quick and the way this group is interacting, this is awesome. So can we have few responses here?
Breach
Ego
of
clashes.
terms and conditions. Breach of
Sorry?
terms and conditions of the shareholders agreement.
Can you repeat that again, please?
Breach of terms and conditions of shareholders
Yeah.
agreement.
Yeah, that's the most prominent ones, right?
Ego clashes.
Yeah. And let's go a little deeper into that. What would be underlying ego clashes? It's actually a flip of what was required to keep the
Position of the
relationship going, right?
positions of the shareholders in the
Sorry?
positions.
Positions of shareholders. Can you elaborate that a bit more?
The board of directors positions.
Oh, so what position each shareholder get in a company, right? The role.
Yeah, role play.
So not getting satisfactory role, right?
Yes.
Okay.
There may develop a conflict of interest over a period of time.
Conflict of interest. Yeah.
Operation and mismanagement. I'm sorry, I'm telling again.
No, sure.
Operation and
Mismanagement.
mismanagement, and operation also, the minor shareholders.
By majority, right?
Minority of shareholders.
Yeah, by majority over minority, right?
Correct.
Yeah.
Also not sharing the profit as per the ratio.
Okay. Yes,
That also
but
covers actually in the breach of agreement.
yeah, the chances of that happening practically are very, very seldom because dividend gets distributed as per the shareholding. It's very difficult to have profits and not distribute in the ratio. What could happen is that profit itself is not there because of related party transaction.
Yeah. Okay. Then removal of directors without following due process of law.
Yeah,
Abruptly
removal
removing.
of directors or important positions without consultation. Now we are coming, I think we started with a little bit of deeper issues, interest kind of issues and moving into positions and how it will surface on. So I'm loving this. So how it will surface on the top. Okay, so I think, yeah, they're all good points. So I think we had guessed it, right? And it's like a flip of what we did on the previous slide, that when, shareholders sense a lack of respect and trust with the other shareholder, when a shareholder wants respect for either being the person who started it or a person who started it with capital, right? And they want respect for that. Other person wants respect for the expertise that they bring, right? They think they are driving the show. They are the ones who is responsible for taking the company ahead. And by certain actions, they interpret it as lack of trust and respect, and one thing and the other balloons into something else. When one of the shareholder thinks that, the person is just a sleeping partner, he invested some money initially, but now he is not contributing anything. I am the one who is working hard. I am the one who is driving the show, and he is just taking all the profits, right? Not all the profit, but whatever, he has some equity and he's just taking it, but there is no substantial contribution by that shareholder anymore, right? Uh, I think we dealt with oppression and mismanagement. So when minority thinks that majority is doing that through, again, related party transactions, by taking decisions not in the interest of company or something like that, when both shareholders share a different direction, we discuss that. Right, one wants a revenue growth model, the other wants to be prudent and want a per unit profit model. When interpersonal issues become shareholder disputes, right? And we dealt with ego clashes there, right? Where, and it happens, right? If they, especially when there are family members who are shareholders also in a company, like two brothers, you would often find that if their wives are not getting together, it will affect how they are working with each other as shareholders in the business, right? If someone doesn't go to someone else's wedding party, they didn't get the respect that they thought they should get in a wedding party, that may affect their boardroom discussions, right? It happens. It's very, very ground reality, right? And then breach of fiduciary duties or trust by another shareholder, like what we discussed. So what keeps one going, and what are some of the common causes of shareholder disputes? So that's what something we have kind of understood till now. Now let's go into, and are there any questions so far? Anything that we can discuss as a group? Because we are now entering into the other main portion of the webinar, and I just wanted to make sure that there are no further clarifications which are required at this stage. Are we all good?
Yeah, Akshay, this was good. I think this was a good stepping point of actually getting to the meaty part.
Yeah. Okay. So now we are getting mediating shareholder disputes. See, I think we all largely understand what mediation process is, and that's why we have joined this webinar, right? So at least we understand litigation is where parties fight in court or in an arbitration proceeding. It's a win-lose, right? Where one party gets their prayers, whatever they ask, and the other party doesn't get. So it's a zero-sum game, right? And they are fighting, they're arguing, using their counsels with each other. Mediation is where they come together, they negotiate for a settlement, and that negotiation is facilitated by a third party neutral called mediator. But ultimately, it is resolving of dispute by talks, discussion, negotiation, and ultimately out of that negotiation, entering into an agreement that both parties agree to. Okay. So with this understanding of what mediation is, again, the floor is open for everyone on why do you think one should be mediating over litigation?
Speedy, it's speedy compared to
Sorry?
the, it is speedy. The result will be speedy compared to the,
Speedy, yeah, speedy. And let's think, what would it mean if it is speedy? Like, how would it help or not help if it is speedy? Because we are also now thinking of company, right? Mediation may be, or dispute may be between two shareholders, but now if a company is big, or even if it is small, it has many stakeholders attached to it: employees, lenders, suppliers, vendors, right? If it's a public limited company, if it's a listed company, then the shareholders like you and me who are holding shares in it, So there are so many shareholders. So what could be the impact on company? Why should we have mediation over litigation?
The win-win situation.
Sorry?
Win-win situation.
Okay, it may lead to, I think we are all coming after reading the textbooks on mediation. So that's good too.
The relationship.
Litigation.
Less cost effective. Less cost effective.
Sorry, one by one. So Sonalji, and then we'll take the other response.
I think the long-term goal, seeing the company has to go on and the business has to run. The relationship has to be in a very amicable surrounding and situation, and they have to go a long way. So the relationship, preserving the relationship, yeah,
So
correct.
preserving relationship, and I heard continuity of business, right?
Yes, yes, definitely.
So you think mediation will help in preserving relationship and continuity of business, but in litigation also business could continue, right? Maybe one person buys someone else out or something happens, but business will still continue.
But it's
Okay.
better not to have an animosity, and the relationships are
Yes.
in a healthier way.
Yes, yes. And let's not forget, why did these two people or more than two people came together? To leverage their strengths, right? So let's not forget, why did they form this company together in the first place, right? And will litigation save that reason why they came together? Or does mediation has potential to really save that, even if they have gone off track, right? Okay. Yes. Any more responses?
So protecting and maintaining the value which has been created by the business.
Value preservation. Yeah. And why would that not happen in litigation?
Well, it may happen now if you take whatever examples that you have discussed. There would be a lot of negative connotation coming out if it is a listed company. It may definitely affect the value of the company. So, for example, in the current scenario, I'm taking an example of the West, what Elon Musk did with Twitter.
Yeah.
I mean, essentially it is almost eroding every day, and now the shareholders have sued Elon Musk that because of his tactics, so-called tactics, the company value has eroded.
Right. Right. Yes. Anything else?
Litigation involves a lot of money, a lot of time, and it's a very lengthy process, and reputation is at stake. So in a mediation, amicable solution can be taken.
Yeah.
Time. Very short time you will get the solution.
Sorry?
Time.
I can't hear you very properly.
Because within short period you will get the solution for your
Yeah, so
litigation.
speedy, right? Speedy, I think.
Speedy, cost, and mental agony.
And what's the third thing?
Mental agony.
Mental agony.
So less stressful, I think.
So saves mental agony, right? Okay. Okay. So I think we again got very, very relevant answers here, and all of us gave us. So this is so intuitive, right? Some of us may have thought that, like Mihir said, I have not dealt with shareholder disputes. I'll be coming with a lot of open mind to learn. But see how intuitive these things are. And there is no rocket science in it. So if disputes are not resolved and goes into litigation, then One, there is paralysis in company decision making, right? So if there are shareholders together and it's like a 40-60, 30-70, 50-50 kind of shareholding, then many decisions need consent of both the parties. And if there is a dispute which is brewing, then decisions get stopped because there is difference in view on every decision. Because of the brewing dispute between the two, conflict between the two, they are not able to agree on anything, right? So it's likely to bring paralysis in company decision making, right? And when that happens, it will definitely affect employees, right? Employees will see that, okay, we wanted to do this project. Now budgets are not getting approved. My appraisals are not happening. My promotions are not being decided upon because this person thinks I am the other shareholders person. This person thinks I am this person's person. And I don't want to get into this. I would rather get opportunity outside. And you know how important critical employees are for running a company, right? There could be customer and supply issues because suppliers, customers may have relationship with one of the other shareholders, right? And now when both are fighting, they may want to move out and they may not get paid on time. They may be under attacks by the other shareholder, right? And they may not like it. Capital investment. Every company needs capital investment. If it is not a company which is generating its own profit to plow in back, then they would need some shareholder dispute, so some shareholder, contributions. And if shareholders are disputing, do you think at that time they would want to put in more money into that company? Answer is no, right? So how will the growth happen? How will more acquisitions happen? It's very likely that there will be a lot of bad press if things are in litigation, because when things are in litigation, whole world knows that you are litigating. Court process is a public process, right? And when litigation is on, no one knows which shareholder is going to win. So all these factors of paralysis, customer supplier issues, they just become more prominent. Banks will be very reluctant in offering loans, and bank loans, every company, mostly the ratio of the company is 70:30, right? So the incentive for the bank loans will be less in a disputing shareholder disputing company, right? And ultimately, all these things are very likely to devalue each party's shareholding in the company. So it's a lose-lose in that way. Like one of the participants said that, the devaluation happens very quickly, and in more so in listed companies, right?
And Akshay, here I might add that these disputes can also affect the credit rating of the company, which can lead to even further problems.
Yeah. So lack of capital investment is part of that. See, credit rating, Mihir, is a function of their ability to repay debt, and that indirectly it will, because if all these issues attack the revenue generation and profitability of the company, because employees leaving, customer supplier issues, then ultimately if they
Yes.
start defaulting on their loans, then yes, credit rating may get affected. Yeah. Okay, so one aspect we just saw, that why mediation over litigation, right? And what could bad go when we are litigating, right? And not just for one shareholder, but it kind of destructs the valuation of the company itself, at least in the short run. Now, the other aspect of mediation is, because generally litigation happens when disputes have reached their peak, when parties can't talk to each other and they have decided to now go to courts or arbitration, right? It doesn't happen in small levels. But how do you think in a shareholder relationship, disputes generally surface? They will just suddenly come up and become peak from day one, or they'll just brew up piece by piece into a big dispute? How do you think they would surface? How would one get to know that, okay, something is brewing up, that things are not hunky-dory anymore? What are some of the signs and signals do you think of those in a company?
Dissenting opinions coming up.
Sorry?
Dissenting opinions coming up on major issues. Dissenting opinions coming up on major issues. Two people are not agreeing and on different opinions.
Mm-hmm. Anything else?
Akshay, for some, suddenly we are losing your voice.
Mine?
Yes.
Oh, I'm surprised. Is this better? I have not done anything but just checking in.
Yeah, we can hear you now, but suddenly a few words are.
Let me just shift my Wi-Fi. It will take a minute.
Sure.
Is this better now?
Yes, overall it's better, but suddenly we lose a few words here and there.
Okay, now it's showing full signal, so I'm not sure.
I can hear you properly.
Okay. Then any more responses? What are the signs of these disputes?
When one feels that trust is being lost, the breach of trust, the trust factor is affected.
Yeah, how would we know that trust factor is getting affected?
Through their actions or some dealings.
Like, what are some of the signals?
Getting to know from some reliable sources about the
Gossips in the corridors?
yeah, maybe.
Okay. Okay, any more responses?
Value of the shares in the market.
Oh, so you're saying already the market has factored that in. Okay. And that would be more relevant for a listed company. Okay.
Misappropriation of the funds.
No, misappropriation of funds is again a cause of dispute, right? It is not how it will surface. It's not how people will get to know that, okay, there is a dispute in the making. Right now, we're talking about signals. Okay. So I think they're all very relevant again. So now we had that on the board. With differences in opinions in board and shareholder meetings, which shows lack of common interest. So earlier, the resolutions which used to get passed in 5 minutes, 10 minutes, because both shareholders had discussed before the meeting, right? And it was a formality to now approve those resolutions. Now there are massive discussions happening in the meetings because they have not talked to each other, right? And they have differences in opinions. And some resolutions are not even getting passed. That's a sign, right? Company secretary who is watching this will understand things are not normal anymore, right? When employees start talking about it and they get conflicting directions. So one promoter asks them, take this approach. And the other promoter says, who asked you to take this approach, right? and the employees are thoroughly confused. Which direction and approach should they be taking, right? And they start talking and murmuring in the corridors about it. And when these differences in opinions actually become vocal, let's say in town halls, in Zoom meetings, in executive leadership meetings, both promoters are taking the executive leadership meeting, and one person is thrashing an employee and the other promoter is actually supporting the employee, you can see that both of them are not seeing eye to an eye, right? Give me 1 second. So if we have to then sum up why we need mediation over litigation, right? Then it has two elements which we discussed. One, quick resolution through mediation saves value of the company, right? We saw how litigation can have effect of devaluing the company, reduction of valuation of the company, preserves or improves relationship. And that was one of the points that Sonalji made, right? Preserving of relationship is one of the reasons why we should adopt mediation, because it was this very relationship which was at the core of formation of the company. Both shareholders thought, because of our synergies, this company will do well. And it is only mediation which can nip the differences in the bud. When these signals are coming, the smoke signals are coming, and parties are wise enough to resort to mediation, then, while things are not that violent, while the storm is not that strong, they can control it. It is a fit case for mediation. But when things have happened so much, there are so many layers and so many ego conflicts have gone beyond, then sometimes mediation may not even work. Parties may not want to agree to resolve. They are now thirsty for each other's blood. And they want either I win everything or I lose everything. I'm not ready to work with this person anymore, right? And that's the case when you have to litigate. And you have to surrender all your power to a third party and say, whatever you say, we will agree to it. We will just convince you by our arguments that you should agree in our favor, but otherwise you will agree to whatever we say, right? So mediation, I think, is a very powerful tool in shareholder disputes because it has potential of not letting small little disputes grow into major conflicts, right? So let's see now how mediation works in a shareholder dispute level. And for that, let's understand what is mediation process and what kind of aspects would a mediator focus on during mediation. So I think we have a few people who are mediators or who are familiar with the process. So any responses, quick responses? What is mediation like? What would mediator focus during mediation? What are the kind of things that you would try to understand?
Basically, the issues between the shareholders and to come up with some solution.
Okay.
Interest of both the parties should be taken care of.
Interest. That's a very powerful word. Okay. Okay, yes. So let's jump into the slide. So first they would understand what is the position of both the parties, right? The mediator would try to, okay, what do you want at the surface level, right? That someone says, I want all the restrictions on shareholder transfer to go away, right? Someone will say, I want equality, I want one more board seat. One board seat is not enough, right? I want the right to appoint CEO. This person has been appointing CEO all this while, right? Someone may say, I want exit, right? So there are different positions of the parties. Then a good mediator, a more proficient mediator would go deep into and understand what are the underlying interests of the party. Why do they want what they want? If someone wants exit, are they facing any financial insecurity? Do they need funds for their other business, for the personal issue? Is the shareholder going through a massive divorce in which he has to give an alimony and he wants an exit, right? What is the underlying interest? Then is it possible for parties to go beyond positions which are either or into their interests? And why of dispute? Why do you want this? Why do you this? This person is a crook. Why do you say that? He did this, he did that. What did you miss there? What would you have liked instead, right? If he would have given me more respect, and there you go, right? He needs respect. What are the different ways in which now respect can be created, right? So getting deeper into issues. And what is likely to be on the surface of the shareholder disputes? Like what would be the likely positions? Any responses? What could be the likely positions? I think there is a chat which I missed. Oh, okay. Yeah. So the likely positions are one shareholder wanting exit and other denying it. There's just likelihoods, right? One shareholder wanting more power on the board and decision making and other denying it. Both shareholders not agreeing to critical decisions that company needs to make. One shareholder wanting the other to be out. They are likely to be their positions. And let's see what their real interests could be. First of all, these need to be explored and not assumed in a mediation. Many a times we judge that, oh, he must be wanting this. But I think we need to be just curious as a mediator, right? That's the whole process, that what could be the real interests? If it's a strategic JV versus shareholder relationship, then meeting of that strategic goal, that I really came into this JV because my raw material business should do well. I wanted, or I entered into this mining JV because I wanted more raw material for my steel manufacturing plant, right? So my strategic goal is not getting met. That could be an interest. More respect and trust, better communication. And you just see how what we discussed in the first part of slides as what is required for a continuing relationship is coming in here as the interests of the parties, right? Better communication, dispute because one party wants exit for need of finances, sustainable growth and more valuation of the company. That could be the very real interest of the parties, right? And they think because you are not contributing, we are not going into the direction we thought we would go when we started this business. And fairness in shareholders dealing with each other, right? Which are surfacing as different kind of disputes. So if we sum up, the whole role of mediation in shareholder disputes, then I would say notice the smoke early and resort to mediation before it becomes wildfire, right? And we can preserve a lot of value there. Mediator needs to explore issues deeper than what shareholders want with empathy and open-mindedness. I think that's the success of any mediation process, and more so in a shareholder dispute. And parties where their creativity had to find solutions which meet their interest to at least preserve relationship, if not improve. And we understand that, cost of litigation is very, very high as compared to mediation. I think that brings us to end of the slideshow, but happy to open the floor if you have time for any question, clarification, discussion, or anything. But I think Mihir has been pinging me on me taking more time. But I think, yeah, but we hear it's just been 1 hour, right? We started at 7:45 and it's 8:45 now. It's not been too long.
No, no, not at all. You did it
I
exactly
kind
in
of,
1 hour.
wrapped up the last session seeing your chat. It's
You
a
wrapped
private
up
window.
exactly in 1 hour. That's an amazing job. I think this, this gave us a brilliant introduction into mediation in shareholder disputes.
No, I
So,
could have used some teasers in the end slides, but I thought of just revealing everything on one go to meet time. But yeah, okay. But happy to discuss any questions. I'm not saying take any questions because that shows me as an expert and I'm not here in that capacity. I'm more as a facilitator with having some experience in this field. But I think thank you to each one of you for enriching this discussion. As you saw, you already had all the answers, right? So it was awesome.
so Akshay, can I just request you to close the sharing? So if,
Yeah,
if
yeah,
somebody wants to speak
sure.
up, we'll put the gallery mode on.
Absolutely.
Yes. So if anybody has any questions, you can raise your hand or unmute yourself.
Yeah, I just want to ask you a few questions actually.
Sure.
First one is about the mediation fee and all. So, is there any cap with regard to the mediation fee which we should fix it up?
So mediation fee will depend on what kind of mediation do you choose, right? So let's say you choose an institutional mediation, there are two foreign parties and they choose Singapore international mediation, right? Then the institute would have fixed certain fee for mediation, and
As per
depending
the
on,
rules.
sorry,
It's as per the rules fixed by the
that's as per the rules, right?
CAP
However,
or LCA or whatever it is. Okay.
yes. However, there could be there could be private mediations where a private mediator could ask whatever fee that they feel comfortable with, right?
But we
And
just created some rules and regulations for the Rotary. I just told you in the
yes,
start.
yes,
So I just wanted to confirm whether there is any restriction or we have created our own rules, even with regard to the fee part.
yes. So it's an institutional rule. So there is no law right now which fixes any fee of mediator, and I don't think that even the bill will fix any bill, if it becomes act, will fix any fee.
Anyway, I think
So,
parties will sign an agreement. So this will also be covered. They will abide by the rules
Yes,
and regulations.
yes, yes. When parties sign an agreement to mediate, they will sign an agreement saying that we want to mediate through this mediator, and this will be the total fee, and we will split this fee or not split this fee. Typically, it gets split because you want to keep the neutrality of the mediator intact. So you both bear the cost of mediation.
I have one more query. I'm sorry.
Yes.
Is there
Deepa,
any
before you go
short-term
on to
mediation?
Deepa, before you go on to your next question, I would just wanted to take up your earlier question. As far as the fees are concerned, like Akshay said, there is no law yet. But if you're trying to fix any fees, uh, for example, the Commercial Courts Act of 2015, okay, under Section 12A, mediation is made mandatory, and there is one proviso to it. If there is any urgent relief required, you can bypass the mediation stage. However, under that provision, the I believe it is Schedule 4 of the Act, which gives uh, a schedule of fees. So if it's under that act, then yes, the fees are given. But if, like Akshay said, if it's a ad hoc mediation or private mediation, as it is also called, then it is up to the individual whether you fix
Parties
a
and the
lump.
mediation.
Yes, whether
That's
you
a
fix a
court
lump sum.
that is a court assisted mediation. There you have a schedule of fees, etc.
Yes, but if
But
you have
that's
private mediation, you could go by session, per session, or you could charge a lump sum mediation fee. So it really depends. So based on the dispute.
Okay, thank you very much. One more question. I'm so sorry. Is there any short-term mediation course which we can, go for?
there are many. There are many. So like what me and Mihir did was IICA. I think there is one coming by IIM in June. So I can share that contact the details with you. If you share your email ID with me, I will forward that email to you. And IIAM is actually, you are right now in Kerala, right? It's a Kerala-based organization. So
Oh, I see.
they
I'm coming back to Mumbai in a couple of
okay.
days.
So but it's an online course, so you
I,
can
okay.
do that. And that's, yeah, there are many which keeps coming up. It's typically a 40-hour certification, and you can do that.
Okay, by the way, is there any restriction that anybody can be a mediator, right? Through experience
Yeah,
also. Is there
anyone.
a
You
certificate
need not be a
required?
lawyer or anything. Anyone can be a mediator.
No certificate is required as such, right?
Yeah, you can be a mediator, but I think doing this training and certification only helps. Yeah.
Thank you very much. Thank you.
Okay.
This
And I think
question,
now I'm taking the question of Mr.
just
Sanjeev
one moment, Akshay.
Khadke.
Just one moment, Akshay. Before we move on, so Deepa, what has happened is, if you take a look at the mediation bill of 2021, that provides that a mediation council will be established, and the mediation council is going to set regulations and standards for accreditation of mediators and registration of mediators as well. So although no current standards exist right now, it is possible that some standards may come in later on when the bill becomes an act and the mediation council sets down the regulations. So I can't say it's better to do it, because then there is a question of where you should do it and which is the proper institute to do it from. So I can't say whether it would be better to do it and from which institution. But like Akshay said, there are many institutions available, and we leave it to you to decide which works best for you. But since you asked about the standards, I just thought I would give you some additional information.
Thank you very much. Thank you so much.
And yeah, Akshay, there is this question from Mr. Sanjeev Khadke.
Yes, yes. That's a very good question. I personally believe, yes, mediation could have been very, very successful in this case, because ultimately, from a distance, whatever I have seen of this dispute, it seems it's not just about whatever was being argued in the courts. It was more about the trust between two shareholders, the kind of relationship both expected of each other and not meeting it. There being a significant difference between the seniority of both stakeholders of different business groups, Cyrus Mistry and Mr. Ratan Tata, right? And there was a particular kind of consultation, communication, respect that parties may have asked of each other. And if a mediator would have dealt with those emotional issues, would have dealt with those interests, I think some solution could have been definitely found out. And it would not have gone the way it went.
All right, I think those are the questions that we have. Does anybody else have any questions? All right. You can always reach out to us and send in or email your questions at info@mediationinitiative.com. And if it is something that you want Akshay to answer, I'll pass on the email question to him, and then we'll definitely get back to you. I hope Akshay won't mind answering those questions
No,
if we get them
absolutely. I
by
would
email
love it.
later on.
Yeah.
All right. So I think Akshay,
But the
yes.
beauty of asking questions in this forum is it's not just me. There are so many learned participants, and we can all use collective wisdom to answer questions.
Yes, exactly. So anyway, all right. So I think we will conclude the webinar now, Akshay. So once again,
Sure.
thank you so much
My
for
pleasure.
agreeing to talk about mediation in shareholder disputes and sharing your experience. I mean, I sincerely believe that with the kind of experience that you have definitely brought forward an in-depth perspective to what shareholder disputes are, what their needs and interests are, and how mediation can be applied when these shareholder disputes arise. All right, so thanks again so much, and we hope to have you back again soon on some another interesting topic. All right. Okay, so just give me one moment. All right. So once again, thank you everyone for joining in, and thank you for supporting us by joining in these webinars. We really hope that you gain and learn from the webinars that we are trying to conduct. And if you need any kind of help with regard to mediation services or training or consultancy, do reach out to us. Our website is www.mediationinitiative.com, and our email ID is info@mediationinitiative.com. So I have been saying this like a broken record, but thank you again so much. Thank you for joining us, and hope to see you again soon. Thank you.
Oh, and thank you for very, very enthusiastic participation. I think this session couldn't have been without participation by all of you. Padma ma'am, do you want to say something?
You're on mute.
You may unmute yourself, Padma ma'am.
I'm sorry. Yeah. Really, it is very nice that elaborately discussed about the mediation, what is mediation, how we can do the mediation. You have given a very good explanation regarding the mediation. At the same time, you have combined the mediation session with the shareholders disputes. Really, it is quite interesting to know about your experienced process. Thank you so much for your elaborated discussions.
Thank you so much for joining in, Padma ma'am. We really appreciate your presence here. And Akshay has just put in his email ID in the chat box if anybody wants to reach out to him directly as well.
Yeah, because I was asked to. Could you please share contact details?
Oh, okay, all right.
I just
I've not
asked.
done it on my own. Yeah.
Okay, great. All right. So I'll just wish everyone a very good night and hope to see you all again very soon. Take care. Have a good night. Bye.
Thank you. Bye-bye.
Lovely session.